Hello, and thank you for joining me today for the Indian Law Outlook at the Supreme Court. My name is Chloe Thompson Villa-Gomez, and I am a principal at the Seattle office of Foster Garvey, and I'm a graduate of the University of Minnesota Law School, and I have been representing tribes and tribal entities since 2005. Our learning objectives for today are first, to recognize the historic nature of the U.S. Supreme Court's recent Indian law decisions. Second, review recent Indian law decisions of the Supreme Court. Third, learn about the Indian law cases in which the Supreme Court has granted cert this term. And fourth, predict what the outlook might be for these cases and future Indian law cases at the Supreme Court. For the period of 1986 to 2001, the late David Getches calculated that tribal interests at the U.S. Supreme Court actually fared worse than convicted criminals who were appealing their convictions. Out of approximately 40 cases decided by the court, tribal interests had a 23% success rate, whereas convicted criminals had a 36% success rate. And over this time period, the tribal interests fared progressively worse. As Getches testified to the Senate Committee on Indian Affairs in 2002, nobody does worse in this Supreme Court than Indian tribes. By my own calculations, for the subsequent period, 2001 to 2017, there was some improvement, but not much. You still see, by my calculations, tribal interests prevailing approximately 33% of the time. And so there were barely half the cases, actually, during this time period than there had been in the preceding time period. So only about 21 cases in this 16-year time frame versus approximately 40 in the previous 15 years. And the issues were kind of all across the board as far as Indian law goes. So it included federal trust responsibility, tribal sovereign immunity, land into trust, tribal civil jurisdiction, tribal criminal jurisdiction, state tax and regulatory authority, ICWA, IGRA, and reservation diminishment. Then we have Justice Sotomayor confirmed to the Supreme Court in August of 2009. And she's been quoted as saying that she actively studied Indian law when she got on the Supreme Court. She went back to the very beginning and tried to understand the foundational principles of Indian law. So this is, I think, a key event in the Supreme Court is the appointment of Justice Sotomayor and her studying of Indian law. Then we have this unprecedented time period of 2018 to the present. So Justice Gorsuch was confirmed in April of 2017, and he does not participate in Lewis v. Clark, which is the only Indian law decision of the 2016 to 2017 term, and that was on the topic of sovereign immunity. But the court has issued 9 Indian law decisions since then, and not counting Yellen versus Confederated Tribes, which I didn't count primarily just because there are arguably tribal interests on both sides. It's essentially Indian tribes in the lower 48 versus Alaska natives. And so I left that one out. So not counting that one, tribal interests have prevailed 100% of the time. And so that, as you can see, is a really big change from the previous, 3 or 4 decades. So this is sort of unprecedented, this time frame here for tribal interests at the Supreme Court. So beginning in 2018 and continuing into 2019, you've got sort of this 1, 2, 3 punch of treaty rights decisions, really powerful decisions in favor of tribal interests. And so the first one is Washington versus United States, which is also known as the Culverts case. And this one's a little bit different because there's actually no opinion. This is the court affirmed the decision of the Ninth Circuit by a divided court. So no opinion is issued, but I think it's worth looking at what the Ninth Circuit said and so what was affirmed. So first, essentially, we have 21 tribes alleging that Washington violated treaties by building and maintaining culverts that impede fish passage. And so the Ninth Circuit affirmed the district court's injunction requiring Washington to correct the offending culverts. The Ninth Circuit rejects Washington's argument that the treaties impose no obligation on it to ensure that fish will be available.